Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we say, this program has been created to inform, help you understand law matters, understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you decide whether or not you might want to handle some issues on your own. If you do decide to solicit outside professional counsel, you'll be better prepared, and so will the professionals you select. Our goal, of course, either way is to help you achieve the best possible results, save time and money as well. We welcome and continue to thank the Bazar and Associates law firm in East Providence who support us and help us with each of the issues that we tackle weekly. And we want to welcome again David Bazar.
Thank you.
Also welcome once again Attorney A. Larry Barron, who's with us, also from the East Providence law firm.
Hi Deb, how are you?
Good. So we had started to speak about the benefits of estate and tax planning, trust planning. It certainly is a way for you to keep some things out of the courts. So we thought today we would delve a little more deeply into it, and whether you're interested in perhaps keeping your estate from those outrageous and enormous estate tax burdens. Maybe you're interested in long-range long-term care planning. Perhaps you have children you need to protect, disabled or otherwise. Lots to know. There are apparently many differences in the trusts, and perhaps you should know a little bit more about how to go about doing it. So let's do that. Briefly, David, let's start with you. So we started to talk about trusts. That's a very separate kind of instrument. Give me a quick overview on it.
Well, I think last time we talked a little bit about the differences between an estate plan that's centered around a will and one that's centered around a trust. The will plan, obviously, any assets that are not titled to somebody else's name and are in the decedent's name will end up being passed through probate and then being distributed to the beneficiaries. In a trust, you avoid probate, and it actually can accomplish a number of different things that I think we may have touched on last time, but Larry can take us into much more depth with what you're able to do with trust plans in terms of estate planning and tax savings and that type of thing.
Just the thought of saving, what did they say, 4 to 7% if you don't have to go through probate, and apparently probate means you don't have to go through that court system at all. It's a different system,
so you will
at least
say,
the trust.
I don't know if you used to say this or not, but it was you can pay me now or pay me later to some degree, because if it goes through probate, there are expenses to probate. It's not catastrophic or enormous, but it is significant. So you avoid those costs. And as I said, there's a number of other reasons that we touched on before, such as privacy and the ability for you to control what's going to happen going forward.
Let's talk about that a little bit. So a trust is a certain and separate entity. How does someone go about putting together a trust? They say, I know at some point I'm going to die, here's my list of things. You could put it in a will, but a trust seems to have some distinct advantages. Even if you aren't Thurston Howell or Bill Gates and with that many significant figures to deal with, tell us a little bit about how one sets that up.
Sure. So most people, when they think about estate planning, they think of it as death planning. And certainly that's what we talk about, but as I tell my clients, death is actually the easy one. The more complicated situation is if you are still here, but you are not able to help us anymore. So the planning that we often spend more time talking about is that very situation. You're here, no one will take your signature anymore, you're not capable of transacting on your assets. And so if you have a trust, because the whole reason that trusts work to avoid probate has to do with this concept of ownership. When we formed our society a long time ago, we said ownership was critical. Without it, we would have chaos, so you get to own your things, I get to own my things. This works very well until something happens to me. The example I use, and it's a little hokey, I left my pen outside, but let's say I've got a book and it's got my name on it, and so I can do whatever I want with it. I can trade it, I can sell it, I can give it away, it's mine. And don't even think about it, it's staying right here. This works well until something happens to me when I die or if I become incapacitated, because my name is on the book and we said nobody else could do anything with the book. The book is frozen until somehow we can strip my name off it, get somebody else's name on it. And the only authority that we recognize that can strip my name off my assets is a probate court. So if you think of a trust as a bucket that holds assets, the magic of doing living trust planning is I take my name off that book and I put the trust name on the book. And now, again, if you think of a trust as a bucket, you just put that book into the bucket, and then when I die or if I suffer a cognitive decline and I say, who owns the book? The answer is not me anymore. It's a technicality, but it's a technicality that works. The book's owned by the trust, and sure, trustees come and go, but the trust doesn't fail. The trust never dies. The trust never suffers a mental incapacity.
So if we're thinking about the fact that there are, I guess, 4 different kinds of trusts that people talk about, the irrevocable, the revocable, a testamentary, a supplemental, those things sound a little bit daunting. Help us go through what they are and what the distinctions are among them, if you would. And actually, if you can, trustee, settlor, what are some of those terms? Who holds the property? What are they called?
Well, I'll start with the easy stuff.
Do the easy stuff,
Yeah.
the easy tutorial.
When we get complicated, we're going right back to Larry. But the different types of trusts you mentioned initially, I think, are on how they're formed. A testamentary trust is a trust that's formed in a will, so the property still goes through probate. The trust is in the will, and the trust creates the will creates the terms of the trust based on the language in that. An irrevocable versus a revocable trust is exactly what it says. You create an irrevocable trust. We do that a lot for life insurance and that type of thing. It takes the control totally away from the settlor, which Larry will explain in a minute, and therefore takes it out of the settlor's estate. You also mentioned, I think you were saying supplemental.
Supplemental?
But were you meaning like a special needs trust?
Sort of, yes.
So it's a different type of trust that you create for somebody who would otherwise be entitled to some governmental benefits, and you want to create a trust that doesn't interfere with those benefits. And then I'm going to turn it over to Larry on living trust and different types of things that you can do with the trust and who the parties are in those things.
Sure. So again, well, let me go back. So every trust has 5 elements. 3 of them are people. We have assets. We have a set of instructions to go along with the assets. What do we do with the assets? And that's true whether we're talking an irrevocable trust, revocable trust, testamentary trust. There are always going to be 3 people, assets, and instructions. The 3 people, the first one is called the settlor or the trust maker. That's the one who creates the trust, and typically that's the client. The second person in any trust is the trustee. Trustee's job is take good care of the assets, invest them wisely, and give them out in accordance with the instructions. And the third person in any trust is the beneficiary. That's the one for whose benefit this whole arrangement has been set up. So in a typical revocable living trust, which the primary purpose of which is to avoid probate, both at death or in the earlier event of a mental incapacity, the client, the person who comes in, they'll be all 3. They'll be the trust maker, they'll be the trustee, and they also will be the beneficiary. And clients also often think, gee, I can be all 3? Well, yes, you can. As I said before, trustees come and go. And so in the instructions, we have a whole list of people who will be the trustee if you can't be. But typically, a revocable living trust, you're the beneficiary for as long as you live. And then at death, this trust becomes a will substitute, and the people that you want to enjoy your assets after you pass, they're the new beneficiaries.
And
So,
you might
one
even
thing-
be able, you might even be able to plan for not just the child, but the grandchildren and the rest. If you're doing.
Absolutely, absolutely.
Yeah, when we were in law school, there was something called the rule against perpetuities,
Right.
which everyone thought was the craziest thing to understand because nobody understood it and nobody could explain it. And it did create problems with what you're talking about is long-term trust planning. The property had to end up in the hands of a person within 21 years of the death in being, which is somebody who was alive at the time the trust was created. It was craziness.
Right.
most states have not all done away with that.
Right, right.
So you can't put in trust
can.
the person who is not yet born?
You can now.
You can
yes.
now, yeah. And the only comment I wanted to make, because Larry does such a great explanation, is you have to go to an attorney who has big hands so they can explain all those things. Go ahead.
Oh, I've heard the term dynasty trust, and apparently that too is not just meant for the Thurston Howells and the Bill Gates, but
Right.
what is a dynasty?
Sure. So some wealthy people a long time ago came to understand that this estate tax, because it's a death tax, shows up every time somebody dies. And so wealthy person decided, gee, you know what? If I leave all my assets to my children, I'm going to pay estate tax when I die. They'll pay estate tax when they die and try to leave it to their children. And so what this person did was they said, here's what I'm going to do. I'm going to set this up so that my children get to enjoy it. They get to have any interest that it earns, income, dividends, all that. But I'm going to restrict their control of this money so that when they die, it's not counted as part of their estate. And so that's what's commonly called generation skipping. And so you can set this up so that it, in fact, becomes a dynasty trust. So it serves your children, it serves your grandchildren, it serves generations to come.
So we started to talk about the idea of not escaping, but certainly mitigating some of the tax issues. You mentioned the inter vivos, the living trust, the thing that's a moving target, can change, et cetera. If I want to avoid some taxes, how does that work? Is that the thing to do, or do I need to look at the other instrument that's called the irrevocable trust? What are the differences between these?
Okay, well, painting with a broad brush, the tax that we're trying to get around is the estate tax, the
Yes.
death tax. And quite simply, the death tax is a tax on what you own or control when you die. So one easy way to get around that is to not own it when you die, to give it away while you're alive. So if you were to, if you had a lot of money that you wanted to get out of your name, say give to your children, but you were concerned about them getting all of this at once, you would want to put it into an irrevocable trust. So it's now irrevocable. So of the three people, I'm the trust maker. I might be able to be the trustee, but I couldn't be the beneficiary. I'd have to put it beyond my control. So that's where you'd use an irrevocable trust, trying to avoid estate taxes if you didn't want the beneficiaries to get it all at once.
Thank you. And for those who want to think about long-term care planning, does the revocable trust work? Does it need to be the irrevocable trust? How about the supplemental trust? How do those things work?
Okay, so now you're talking about trying to qualify for Medicaid or medical assistance, which
The eligibility issue, yes.
which is the program that pays for long-term care in a skilled nursing facility. That clearly needs to be irrevocable.
Because?
Because Medicaid looks at a trust, and if you have any rights to it, you are assumed to have full rights to it. So they want you to use what's in the trust to pay the nursing home. So any kind of Medicaid planning would, the most conservative way to do it would be to put it into a trust and keep no rights to any income, no rights to any principal, a firewall between you and the asset.
Is there still a look-back period for that?
And there is. There's a 5-year look-back period
Still?
in most states, yes. And you say still, I'm guessing that it's actually going to become, at some point, maybe even 7 to 10 years. Not to get political on you, Deb, but
She likes politics.
with Republicans in charge, they are always looking to look for ways to balance the budget, if you will. And Medicaid is often the Medicaid programs, welfare programs are typically the first programs that take it in the next. So under current law, it's 5 years, but if they were to increase it to 7 years or 10 years, it would have a salutary effect on balancing the budget.
So in this current climate, yes, political as it may be, tax reform is certainly supposed to be one of the big issues on the table. When people want to think about gifting away or leaving it in a trust, somebody has to pay taxes on these assets. Assuming that someone wants to put an estate plan together, who's taxed when, and when should they be taxed? And same question applies to gift taxing.
Sure. So the gift tax concept is a federal concept, mostly. Rhode Island, for example, does not keep track of gifts that are made, even gifts that are made the day before you die.
Up to how much?
They don't keep track at all. You can give everything away the day before you die, and when you die, from an estate tax standpoint, they say, oh, you don't have anything, next.
Right.
So Massachusetts, they do keep track of the first $1 million that you've given away during lifetime. But in any event, the federal gift tax program works like this. Any gift that is in excess of, it's currently $15,000, it just went up. Any gift that's in excess of $15,000 to any person needs to be reported to the federal government. You don't pay tax on it until you have given away what is currently will be, $11.2 million. That's just gifts. Once you've made gifts in excess of that, you need to start paying a gift tax. When you die, on the federal side, you need to report what did you make in the way of reportable gifts. Again, those gifts that were in excess of $15,000, and that eats into the $11.2 million that you can leave at death. But most states don't account for gifts.
Right. And just so what he's talking about is important planning, because most estates that we see, not all, but most, it's 11.2 million federally for each spouse. So it's 22.4 million, and they can gift away during their lifetime money and not pay tax on it if they're within those parameters, and there is no state tax on that gift. When you die, in Rhode Island currently, if you die with $7 million in your estate, there's not going to be a federal tax, but there will still be a state tax. So if you had that $7 million and you were able to afford to give it away during your lifetime, you would have avoided all tax.
Right.
And while we say we certainly want to help individuals, also we want to help businesses. You're an individual who has a business. That business has assets. You have some ownership in that business. What are your estate or tax planning or estate planning options to protect it financially, as well as tax-wise, as well as the child who might get it? What are some of your thoughts about that?
Wow, that's a long conversation.
It was a long question, too.
Because I guess the first point of attack would be the desire on everybody's part to have this business be viable in the next generation. So part of the counseling that we would do would be to hear loud and clear from the current owners. Is it a one-woman or one-man operation? Are there more than one owner? Do we have a next generation ready to assume leadership roles? There's all of that. And then once we know where we're going, then we can kind of scope out smart tax ways to do it. But the most difficult part of that conversation is how do we transition? Oftentimes entrepreneurs are reluctant to let go of this is their baby, they've created it. So counseling clients to let go.
So what I hear you say, I believe, is that is not a one conversation, one session decision. It might start at 1 hour session, but it's protracted over a period.
As Larry says, it brings in a lot of different issues that really need to be discussed out. What are the estate, what's in the estate besides the business? Because now you have, let's say, 4 children, and the business, which is the bulk of the estate, and other assets, and maybe 2 of the children will end up in the business. So how do we as the person passing everything along, how do we be fair to all of our children? And there's actually a number of interesting ways that you can make sure that the two children in the business have control over what happens in the business, but that the other two aren't cut out totally because they aren't not enough assets otherwise to give to them to balance what's being passed along. For instance, you can have different classes of stock where the two who are in the business might have the voting shares, but the ownership is equal, so that if at the end of the day they sell the business, everybody's treated equally, but those who are in the business don't have to worry about the other two controlling the business, so to speak.
Yep, exactly.
To add another wrinkle, but perhaps it isn't one, if you own a percentage of a business, you might want to pass that along, but not necessarily is that child going to be in the business. How do you plan for such a thing? And it's not as if that child who acquires that business upon your passing, it's not as if they're going to continue to make it grow. They might not even be able to sell it because who knows what, it might not be marketable. How do you factor all those things in? Is those part of a trust situation, or is that a business valuation counselor, or is that a tax planner? How does that work?
So again, hopefully you get around the table everybody who has a stake in this business. And so if, for example, I'm in business with one or two other people, and I've got one child, make it easy, I want my child to benefit, but I'm going to be looking at my other two partners and say, you know what, he's not going to want to be involved in the business. You also don't want him calling, every week, where's my money, where's my money? So let's try to work something out now so that, it can be clean, so that he can get the value, my child can get the value of my interest, but you're not, tied up with him and he's not tied up with you.
Yeah, it's those other partners. Really, now it's a business plan for them to have insurance, perhaps,
Yeah.
to buy out someone's share. Whatever the stockholders' agreement, I guess, is where we would go with that, to make sure that everybody's on board with the same thing in the event of somebody dying. Sometimes they used to call it key man insurance or something, but it's really money to fund a buyout if it's not going on to the next generation.
Right.
And not to get into the weeds about valuation, discounts, and the rest. You folks, as lawyers, might meet with the children, perhaps. Would you also likely bring in accountants and other business consultants as you're doing this? Because this is, as you said, not a one and done, as they say. Is this a long-term planning process or an ongoing one?
Sure. We get to a point once everybody has said what they want, what their vision of the future is for this company. We get to a point where if people are going to be going their separate ways, we need to find out what is it worth. So absolutely, you'd want a CPA to weigh in. You'd want someone, if the company is worth significant amounts, you'd want a business valuation done. So everybody feels that they're being treated fairly.
It takes time, you say, to put these trusts together, an estate plan, and in some cases you say that you need to reevaluate it when a situation changes. How often do you suggest that the revocable trust is reviewed? And is there any reason to review or go through the process of what it takes to change an irrevocable trust? Understanding that's a little more cumbersome, if not impossible. Not impossible, but
It could be.
Sure. Do you want to take the...
No, that's
Okay, so people typically will do their planning. Let's assume that they didn't do their planning when their kids were young. They should have, but they didn't. So the next logical time, if you're going to do planning, is perhaps when you're on the cusp of retirement. You're looking at a new phase of life, so you want to know who do I want in charge and where do I want my stuff to go. The next logical time would be after, if in the case of a married couple, after one spouse dies. Typically, we sit down with the survivor and we say, okay, here's what we planned 10 years ago. You tell me, does it still make sense? As we go about settling the estate of the first one who's died, does this still make sense? And asking questions and lining up the right people. And then So maybe 2 times. Certainly if there's a significant change in circumstances, either on the wealth side or on the family side, you might want to make a change.
Is it reasonable to assume that your client has to always be the one to reach out to you when a change or is either imminent or whatever? Or are you able to, as the one who is the document keeper, are you likely to say, I notice it's been a decade, should we? Or do you always wait? What's the professional rules about that, or what's the thought
Ideally,
about that?
or in the real world?
Real world, let's do real world.
Yeah, I would say I wish I wish I could do that. But my clients, so let me back up. Most people don't do estate planning. So the 20 or 30% that do it, these are people who care about their family. Estate planning at the end is an act of love. They don't want to leave a mess behind. So these people are pretty proactive types of people. They will typically, when there's a need, they'll call. I certainly welcome clients to, so 2 things. A, to make a change, or B, how did this work? We did this 10 years ago. I don't remember. How does it work? Can we sit down and you can explain it to us again? Absolutely, come on in.
That's how that goes. So we talked mostly about the money side of this, and you mentioned there's the secrecy privacy side of having a reason to have a trust, but other things, as I was reviewing, there's a divorce you might want to plan for, plan after. You have a child, a sick child. You have a child who just doesn't do things as one would expect. All of those kinds of things are reasons for someone to start to have an estate plan or a will, or all combinations, not just they have 6 figures, 10 figures. Are there other things that come to mind?
As I said, putting together an estate plan, and the answer is not always a trust. Basically, when I sit down with clients, I ask them, what do you want to accomplish? And basically they say, I want to get my affairs in order. I want it to be simple. I want it to be cost as least as possible, as little as possible. And so we customize the plan to who they are and what their assets are. And so if they don't have a lot of assets, there are other ways to skin the probate cat than with a trust. So we'll talk to them about other ways that we can do this.
We always say it's about the people and what the family dynamic is and what people need. So while we've talked about the 5 things that go into a trust, the things that go into the estate plan are the same, but it's the property and the people that really need to be talked about. And so you have to know who the people are and what the needs are, as Larry said, and then you go from there.
I know we certainly didn't even touch on insurance plans and the rest that can be done, but at least we did get to have a quick overview. We hope that this has been helpful to you in your planning. We hope that you will continue to stay tuned to the Law Matters. Thank you, David. Thank you, Larry. The Law Matters to you.